Hi, my name's Phil. I like talking about politics, and the third day of hearings at the Supreme Court on the issue of prorogation has now taken place. It's all concluded. We're just waiting for the verdict, which the President of the Supreme Court announced would hopefully be early next week. What it's supposed is at the moment, rather than getting a decision, which we may have in theory got tomorrow with reasons to follow, I think possibly because of the intensely political nature of this case, they want to give their decision at the same time as they can also give a load of reasons for it. So I think some sort of report is going to be written before they announce the verdict, and that's why it'll take place after the weekend. Now, what I want to talk about in this video is a couple of things. I'm not going to do a blow-by-blow account of the whole day because a lot of the cogent arguments took place in the first 2 days. I want to go over Sir John Major's intervention, former Prime Minister, and then the very interesting interaction between Lord Panic and the judges at the end of proceedings as well. But first, if you find yourself enjoying the video, please click the like button and subscribe to the channel. So, first of all, and what's really important with all of these videos, this is now the fourth video on the proceedings I've done, and I just need to be really clear, especially based on a few comments I've been getting. When I have been expressing opinions in any of these videos that are legal opinions, they're not my opinions. I am not qualified to offer up any legal opinions whatsoever. So I've had various people, and some people have said, you know, I'm legally trained. There's different levels here. At the moment, I'm base level. I'm literate. Actually, that's it. That's the best I can say. I'm not legally trained. I don't understand court procedure without having it explained to me. I don't understand British constitutional law, or at least the fineries of it. I don't understand what powers the court does and doesn't have because I'm not a lawyer. Someone who is trained in law doesn't necessarily mean they know much more than me. They may you would hope they know a little more. But again, you know, there's experience to go with it. When I think about, you know, when I first qualified as a teacher, and now I'm just as qualified now. It's the same qualification, but I've got way more experience. I'm way more knowledgeable. The same would be the case there. Then, of course, it's not even just about training and experience. Are you experienced in the right area? If you're not experienced in British constitutional law, not that useful. You'll notice there are 11 Lords Justice, getting that right this time, someone picked me up on it yesterday, sitting here. There are 12 altogether. They needed 11 so that it can't be deadlocked. So who was the one who was asked to sit out? Someone who's an expert in business law. Not really relevant to this, did without them. So there's other things like that. And then, of course, even with the people who are trained and experienced in the right areas, there are still superheroes within that genre. Lord Panic QC, who has, you know, been effectively, he was appealing the High Court decision. So certainly against prorogation. You know, I've been seeing various people who are established experts on British constitutional law absolutely gushing over him. Proper man crush some of these people have got on him. So he's, I don't really know him, but he's clearly a monster in the field, an absolute hero, a towering giant. So as you can understand, with all due respect, if I'm going to go with anyone's legal opinions, it's only going to be with established experts in that field, So without further ado, we've got that out of the way. I'm going to go through a few things that Sir John Major's intervention went. He didn't speak up himself. Of course, he had an advocate like everyone else does. So the first part that I want to go through, it was very good, was what he submitted to the High Court, but it didn't hold any water there. So I'll read a couple of bits out. So he's talking about the fact, so what the High Court basically said was that prorogation is a purely political matter, which is something the government wants to emphasise. And the High Court basically agreed with the government that there are no circumstances under which prorogation could ever be a matter for the courts. So what he said was, well, if you're going to say that's correct, he said, in the context of constitutional settlement in which Parliament is acknowledged to be sovereign, that would be a remarkable position for the courts to endorse. It would follow that the courts would not intervene even if, for example, and he gave 3 scenarios, which would all be perfectly plausible if the courts decide that the Prime Minister can prorogue whenever he wants, for as long as he wants, and for whatever reason he wants. He could do all of these things where he's so minded. Scenario 1. So Parliament wished to abolish the power of prorogation, and a bill to that effect passed through both houses, Commons and the Lords. But before it could receive royal assent, the Prime Minister prorogued Parliament so to prevent it coming law. So what happens is you've got Parliament who want to get rid of prorogation. Because we need something to separate out sessions. Every country has something that does the same thing. Prorogation isn't the only way to. It's an ancient device that has worked so far. It's not been a major problem because we haven't had anyone come in and abuse it like Johnson has. So you could argue now Parliament will set its sights on getting rid of it, but nonetheless, let's say Parliament wanted to get rid of it, he could just stop it. He could. Before it gets royal assent, which is what's needed to get it on the statute books, he could just prorogue. And then all that bill is lost completely. They have to start again when they come back. And then when it gets to the end again, he just prorogues again. And he can keep doing that ad infinitum. Second one should be scary for a lot of people. So let's say you've got a Prime Minister philosophically opposed to the idea of a standing army. Wonder who they could mean there. And they prorogued Parliament during the period leading up to the statutory expiry of the relevant Armed Forces Act, with the result that the Act expired and the armed forces were required to disband. So here you'd have a situation where the Prime Minister could prorogue and force, against Parliament's will, they could force the disbandment of the Royal Air Force, the Royal Navy, the Royal Army, the British Army, all of it. All gone. We don't have an army, we don't have a navy, we don't have an air force. On one person's say-so, against Parliament's wishes. Third one, which is less extreme, but perhaps more relevant. A Prime Minister prorogued Parliament before the outcome of a confidence vote, which his whips had calculated he would lose, for no reason other than to prevent it being recorded that he'd lost the confidence of the House such that he would need to resign. So in other words, let's say Parliament get ready to issue a vote of no confidence, he prorogues Parliament, so he stays as Prime Minister. Nothing he can do about it. Nothing Parliament can do about it then. That's it. They're using the device that is supposed to be used to get rid of a Prime Minister, but he is able to say, no, you're not using it. Now, those are three ridiculous scenarios. Now, what the High Court tried to argue was, they said that it was unhelpful to consider arguments by reference to extreme hypothetical examples. But what Sir John Major is arguing, he says, the use of a hypothetical example is a standard method for testing the logic of an argument. If a particular legal analysis would in certain situations produce absurd or intolerable consequences, that is a strong indication that the analysis is wrong, or at least it requires qualification. He then went on to say that if you are going to say, as the High Court, there are no circumstances under which the courts can involve itself, then actually you are more than justified in using extreme hypothetical situations. Because if the High Court were only saying, we can't interfere in this case, then fair enough. But they didn't. They didn't even consider the circumstances in this case because they took the view it's none of their business. So, anyway, there was a few other things. Now, I want to just go over the very last bit he said before I get onto the very interesting interaction at the end of the day. So this was to do with the fact that the government have refused to provide any witness statements as to the truth, the whole truth, and nothing but the truth of the documents they've submitted to court, which is extraordinary. Witness statements are normal. All the judges have said this. They've all been querying the government barristers. It's normal to have a witness statement. Why haven't we got a witness statement? We need a witness statement. So they haven't got one. So he goes, his final point is here's the current factual picture on the material which is available and with regard to the absence of evidence which ought to be available but has not been provided is deeply concerning. The court is under no obligation to approach this case on the artificially naive basis that the handful of disclosed documents, in other words implying that it wasn't even a complete set of documents, the contents of which nobody has been prepared to verify with a statement of truth, should nevertheless be assumed to be an entirely accurate and complete when even members of the cabinet do not appear to believe them. It would also be wrong to proceed on that basis because it would mean that the real issue that has arisen on the facts would not be resolved. Which were excellent arguments. I thought they were worth putting in. So, what then happened? In the final session, you had Lord Keane again for about half an hour and then Lord Panic, who appeared to go for over half an hour because there were a lot of discussions happening at the end. And again, this is not my view. This is experts noting this. And this is what gives me confidence. Here's what seems to be likely to happen. They all keep saying you can't prejudge judges. Sorry for that expression. We can't. But there is more than cautious optimism to believe that they are going to rule this prorogation unlawful. Now, the reason for this is not simply that the arguments against prorogation in this case were so strong and that the government's position was so weak, because you can't tell that. I'm not qualified to tell that. You know, it's the Supreme Court judges that are the only ones who can infer from that. However, what a lot of people that were watching these proceedings were noting, and I was at work, I'm afraid, but what they were noting was the judges spent a lot of time in the afternoon, and I mean a lot of time, discussing remedies. Now, what's the remedy? So let's say they declare prorogation unlawful. The court then has to decide what it's going to do about that. It could just declare it unlawful and leave it at that. I was talking a little bit about that earlier on today, wasn't I, in today's video? Or it could issue a court order. But what would the court order say to make the government comply? So there's a lot of ways the court could proceed. But if the court was going to determine that it was lawful and it's none of their business, then there are no remedies. There's nothing for them to do. They just simply say, actually, sorry, we have to accept the government's position that it is purely a political statement. Now, given that this was at the end of proceedings, the judges at this point, at least on the matter of the verdict, have probably largely made up their minds. They're now thinking of what they do about it. Why spend so long discussing different ways in the event that they declare it unlawful that they would wish to proceed? And it was a long time spent. It wasn't just, and it wasn't at the, it wasn't the Lord Panic who was coming out with all these. It was the judges asking, how would we proceed in this case? So that gives us, as I say, more than cautious optimism that they are getting ready to declare it unlawful. They are saying that this is outrageous, which it is, because let us not misunderstand the situation. If they declare it lawful, this is what will happen. Now, this doesn't necessarily guarantee Boris Johnson victory, but this is still what will happen. Obviously, if Boris Johnson wins this case, Parliament is suspended until October the 14th. Then they come back for the Queen's speech and to comply with the amended Northern Ireland Act, Section 3, before summer, they have to report to Parliament on progress towards ensuring that Northern Ireland isn't completely buggered in the event of Brexit, and their report is likely to be, sorry, it's completely buggered in the event of Brexit. But they have to do that to comply with the law. Then there will be nothing stopping him from just proroguing it a couple of days later. Just straight again. Before they can even legislate, before Parliament can even legislate for anything else. He can just prorogue them again. And he will do for the rest of October. Now, that doesn't guarantee he gets his no-deal Brexit, because remember, the Benn Act will compel him. There would be another court case there and all the rest of it. But without Parliament sitting, it's tricky. It is tricky, because if it had just risen for a break, then Parliament could still carry out some duties. But when it's prorogued, it can't. So it can't, for example, if Boris Johnson point blank refuses to sign the thing, even if it means falling foul of the law, Parliament can't replace him because they're prorogued. They can't, they can't try and enact some legislation to allow them to make a representation to the EU Council themselves and bypass the Prime Minister. They can't do any of that. They can't even make a humble address to the Queen to try and get her to do that. None of these would be possible. So if he was willing to go to jail for this, and I strongly suspect he's not, but if he were, then he could get his no-deal Brexit. So that's how serious this is. But like I say, I was heartily encouraged by the proceedings at the end, and the judges so keen to explore remedies, which are totally useless if they find that it's none of their business, because there is no remedy to apply in that case. So anyway, I hope you found the coverage interesting. If you'd like to support the channel further, then please click the Patreon link for details. And until next time, I'll see you later.